Within Canada, and then I'll tell you a bit about restorative justice, especially in the context of criminal law, and then I'll give you a bit of my thoughts on that, some of the outcomes, and some of the critiques also to the initiatives that have been taken by Canada with regards to restorative justice and Indigenous people. And if there are any problems with the translation, please don't be shy, just lift up your hands. Okay. So to start off with, for those of you who don't know, I'll be very brief on this, but there are about nearly 1.5 million Indigenous people in Canada, and they're divided into, legally speaking, 3 groups. The first one, legally speaking, are Indians, though it's not a term I would encourage you to use if you come to Canada. The term the more politically correct term is First Nations people. However, legally speaking, we still have a law in Canada that is called the Indian Act. So if we're going to be technical, the term, the Indian Act is still in force today in Canada. We also have Inuit people. So, and just as a way of background, Indians or First Nations people in Canada reside on reserves. We do have reserves in Canada, but they also reside off reserve. So the Indian includes all of those people. There are also Inuit people. So if anyone, another term that was used to be used to describe Inuit people was Eskimo, which isn't politically correct anymore, but these are people in northern Canada. They also share an ethnicity with, for example, the people of Greenland and Alaska. And then there are the Métis, who are a mix of the Indigenous people and the French when the French first arrived. So especially in Western Canada, there was a lot of mix when the French first arrived to colonize. It was mostly men. So there was a lot of mix, and they developed their own culture and language. So a lot of French Canadians like me are darker skinned because there was a lot of mix in those two cultures. So just by way of background, Indigenous Canadians represent about 4.3% of the population, but they're very diverse. There's not just one Indigenous people. There are about 600 different governments, Indigenous governments in Canada, and there's about 3 languages that will probably survive, 6 languages spoken quite regularly in Canada. And the history of Canada and Indigenous people is one of colonization and one of forced assimilation. One of the first laws with regards to Indigenous people was the Gradual Civilization Act of 1886, and the Indian Act, which I referred to, which is still on the books today, the Indian Act. Originally, both of these legislations were meant to civilize Indigenous people, and these were passed once the British arrived to Canada. So, for example, to force sedentary living, agriculture, and education, banning of cultural practices, and the creation of reserves in Canada. So you may have heard of these. They have them in the United States, but reserves were lands dedicated to Indigenous people, which were originally set up as experiments to civilize Indigenous people and to teach them the European way of life. There's a history of unlawful appropriation of the land. When the British arrived, they made treaties to take the land from Indigenous people. Most of these treaties have not been respected. And also the treaties were inherently unfair because according to the treaties, Indigenous people were conferring the land. In Indigenous culture, they never thought of themselves as owning the land. No human can own land. So to confer the land for them was a non-starter. There's also some land in Canada that was never ceded by a treaty. So, for example, you see this picture? This is your president and our prime minister. This is in our capital, Ottawa. They went for a jog last week. But this Ottawa is actually on unceded Algonquin territory. So it's very common. So it's right now, there's legal battles about whether or not, who this lands belongs to, because it was never appropriately ceded by a legal document. So our parliamentary buildings that you see behind this are located on territory that belongs to Algonquin people. Part of our story is also residential schools. In Canada, there was a policy, again, of forced assimilation, of creating schools that were founded and organized and implemented by the government and the church with the express intention, and this is taken from government documents, to kill the Indian in the child. So children were forcibly removed from their families and taken and prevented from speaking their language and exercising their traditional practices. And the last residential school closed in 1996. So if I were an Indigenous person, I would have gone to a residential school. I would have been assimilated. So now in Canada, we're really dealing with the legacy of hundreds of thousands of people who went to these schools, who lost their culture, who lost their identity, who never got to grow up in their communities with their parents, and who very often were victims of physical and sexual abuse. And we just finished the largest legal settlement in Canadian history. The government officially apologized to Indigenous people for residential schools, and just gave out, in Canadian dollars, it works out to 1.6 billion, but in pesos, it's about 24 billion pesos that they gave out to survivors of residential schools. So this is the official apology of our Prime Minister for residential schools, and you'll see in the front of the picture, there's some Indigenous people in traditional dress. So since the 90s, there's been a change in culture in Canada. There's been a recognition that we've done things wrong, that assimilation and forced civilization is not the solution, and there's been a movement to recognize Indigenous people not like a minority that we need to deal with and grapple with, but like a nation, or like many nations who have autonomy over their laws, their land, and their practices. So we still obviously have a lot of work to do, but more and more that's been the trend, and that was one of the recommendations made by the Royal Commission on Aboriginal People in the 1990s. The Royal Commission also recognized, and this is widely recognized in Canada, that our judicial system has been a complete failure with regards to Indigenous people. This is a complete consensus that our judicial system, especially with regards to criminal law and Indigenous people, does not work, is a complete failure because it creates disorder rather than order, which is the opposite of what a criminal justice system is meant to do. So the consequences of this are that very often in Canada you hear that there are two Canadas. And by way of example, the poverty rates consistently in Canada, when Canada is ranked for example, the quality of life of children, we usually rank between 4th and 5th in the world. We do very, very well. We have good schools, we have good hospitals, our children do well on the international scale. However, if you consider just the quality of life of Indigenous children living on reserve, Canada ranks about 78th, so below many developing countries. The conditions on reserves are dire, and if we had pictures here, you probably wouldn't think that this was happening in Canada, but there are a lot of reserves in Canada. Generally, people can drink the water from the tap. On reserves, it's very rare that this can happen. There are high suicide rates, underfunding of schools. It's a dire situation. 1 in 2 children in Canada, Indigenous children, live in poverty. And what that translates into is alarming overrepresentation in prisons. So as I said, about 4% of Canadians are Indigenous. about 23% of our prisoners in Canada are Indigenous. In some areas, like the area where I'm from, it's up to 80%. For women prisoners, the situation is even worse. There's some areas where about 87% of the prisons are Indigenous women, coming from a pool of population of 4%. So there's clearly a huge problem. With that, restorative justice principles were taken because everyone acknowledges that there's a huge failure. And what's appealing about restorative justice is that it really corresponds with a lot of Indigenous worldviews. And though there are many different Indigenous communities and different traditions, there are certain core values that remain true in most Indigenous communities in Canada. The values of love, wisdom, respect, bravery, honesty, humility, and truth. There is a deep sense of community rather than individuality. The manner in which people define themselves are in relationship with the others. And their concept of justice, though I have a lot to learn, is one based on peace and equilibrium in the community. Creating a stable, peaceful community is very important. And their concept of justice is not detached from other aspects of their life. So it's not compartmentalized as being separate. It's certainly not about punishment for most Indigenous people. And participation is very important. So in light of this, there were two major changes, I think, in the criminal justice system with regards to Indigenous people in the 90s to incorporate restorative justice and Indigenous values into with regards to the manner in which we incarcerate and sentence Indigenous children, criminals, sorry. So firstly, with regards to sentencing, and secondly, with regards to the release. So firstly, with regards to sentencing, I'm particularly proud because the University of Ottawa's former president was the Minister of Justice when this change came into place. In 1996, the criminal code was amended to section 718 to allow judges, or not to allow, to require judges to take into account the Indigenous background of an accused when sentencing. So this was to recognize the individual and systemic discrimination experienced by Indigenous people. So this comes into play into two ways. Firstly, with regards to guilt. So when examining someone who is accused, you have to consider the unique ways or factors in which Aboriginal identity may have been a contributing factor to in criminal activity. And secondly, with regards to sentencing, you have to consider whether there are alternative means to incarceration that would be more culturally appropriate for the accused. And basically what this means, and what the courts have decided that it means, is that incarceration should really be used as a last resort. So the Supreme Court of Canada interpreted the provision of the Criminal Code in 1999, and that what they said is this isn't a get-out-of-jail-free card, but that incarceration should be really used as a last resort. That this provision should be interpreted broadly to apply to Indigenous people living on and off reserve, and to all people of lifestyles. And so you don't have to be someone who embraces Indigenous traditions, who speaks the language. The fact that you're Indigenous and have experienced discrimination can manifest itself in many ways, even if you live in a city and have a regular job and go to school with non-Indigenous children. So the courts have been interpreting this very broadly, and recently there was actually a decision. It was someone who was accused of, who committed a crime, and he was in his early 20s, and he had been, he was Indigenous, but he actually didn't know he was. He had been adopted because his parents were survivors of residential school, so his parents had problems, socioeconomic problems, so he had been adopted by a non-Indigenous family. But all his life he struggled with a reality or maybe a sense of not belonging, didn't understand his identity, which was the judge found to be a factor in his criminal behavior. So at the time he committed the crime, he didn't know he was Indigenous. He found out later, and when he appeared before the judge to receive his sentence, he argued that he should be entitled to a lighter sentence, and that Section 718 should come into play. And the court agreed with them. They said, even though you didn't know you were Indigenous, this is exactly the kinds of social factors that may cause Indigenous people to experience criminality, whether they know it or not. So the provision's been interpreted very broadly. Oh, I think I'm missing a slide. Secondly, I'm sorry, there seems to be missing a slide, but with regards to sentencing, this is something that has been happening. It's not anywhere written in the criminal code, but judges have been doing it on their own, which has been organizing sentencing circles. So when someone is accused of a crime and the person is Indigenous, it's to turn to the community to organize a sentencing circle and ask the community, and sometimes including the victim, but not necessarily, ask the community to chime in and to give their advice on what they think an appropriate sentence would be. So like I said, this is not expressly in the criminal code. It's completely discretionary. However, as a tradition, it's only applied when people plead guilty and to serious offenses, because it's a really lengthy process of going to the community. These communities are often very isolated and rural. And it's not a diversion process either. It's part of the court process. So there's certain requirements because it's not formally recognized. It has to be open to the public. There has to be a record of it. And the people participating in the sentencing circle have access to all of the documents, the court records. But in general, what happens is the members of the community, where the accused will be returned to after his sentence, have a discussion about what are the causes of this criminal behavior. Is it a problem in the community? What is the impact of the victim? And what do we think an appropriate sentence would be? And generally, the sentencing circles meet 1 or 2 times for 2 to 8 hours. And everyone has equal standing. I'm really sorry, I thought I had put a picture, but I guess it's not here. So everyone has an equal standing. Everyone's sitting in a circle, and everyone shares their opinion in a non-hierarchical matter about what they think an appropriate sentence would be. So that's another innovation, I suppose. The second changes are with regards to the release. In general, there are 2 provisions that allow, once someone is in the process of serving their sentence, so after they've received a lighter sentence generally, because they were recognized as that the Gladue test was applied, that the systemic discrimination was considered. Once they're in their sentence, they have the options of serving their sentence in different ways. So not necessarily going to prison. Firstly, I think what's most interesting is these are healing lodges. Again, so this is a very different approach to see criminality, that it's not about punishment, but it's a process about healing. There's a provision of the Correction and Conditional Release Act that allows Indigenous people to serve their sentences in healing lodges rather than prisons. Obviously, there are certain conditions to this, but the vision of this is to be, the vision of this is to take into account Indigenous tradition, to be culturally sensitive. They're also more cost effective. It's been proven they've been running for about 20 years now, and it costs less to put someone in a healing lodge than it does in prison. So the vision behind this is that the prisoner, before he's released, will agree to a healing plan with spiritual guidance, and he'll follow the rules and develop a plan with the community for his integration, or his or her integration into the community. And finally, I'm just looking at the time. Section 86 of the same legislation, which allows communities to adopt a plan to integrate criminals. So again, rather than serving their sentence in a traditional prison, the community can proactively propose a plan to integrate the person into the community, to offer support such as an elder, so this is a spiritual guidance, traditional activities such as hunting and fishing, and spiritual guidance and healing. Again, this process can involve the victim, but not necessarily, and there's certain conditions to take part in this conditional release. So I'll leave a bit of time for questions, but I'll talk a bit about the impact. Simply said, we're still studying the results, and it's very difficult to measure the success of these initiatives because it's hard to compare. For example, for the sentencing principles, it's being applied now to all Indigenous peoples, so it's hard to compare what it would be like if we weren't applying these principles in sentencing. One thing we can say is there's actually the incarceration rate in Canada of Indigenous people since the 90s has gone up. It's gone up at the time that these initiatives were first put in place. It was about 15%, and now it's 23%. Though I'll talk about that, I'll comment about that, because I don't think it necessarily means that it's not working. But in terms of reoccurrence of crimes, there is a slight reduction in criminality of individuals who are streamlined through a process of a healing lodge or community, but the numbers are not as encouraging as we would think. So about 8% for adults and 2% for young people. That being said, there's been studies of the people who go through healing lodges. Their experience is generally very positive. They feel more connected to their community. But again, the rates of reoccurrence of crime, there hasn't been any statistically important change. And obviously, I'll just give you my thoughts on this. I think it's maybe oversimplistic to expect a direct correlation and direct change immediately. There are a multitude of reasons why people commit crimes. And for Indigenous people to expect that this little piece of the puzzle will be the solution to the over-incarceration of Indigenous people, I think is very oversimplistic. So I think that the approach to this is to, first of all, look for other solutions to treat Indigenous people like a nation. And when we will be at that point, I think the incarceration rates will drop. To advance human rights, to eradicate poverty on reserves, for example, education, but also to cease to see restorative justice principles as a means to an end, but rather an end to themselves, that these processes are more culturally appropriate, and they take into account Indigenous traditions in a way that our traditional system doesn't. Some of the critiques with regards to these measures that have been applied is, firstly, with regards to sentencing. As I said, there's huge diversity of Indigenous cultures and traditions in Canada, and they're not all light on crime. And there are some Indigenous traditions that do advance a vision where penalizing is appropriate, and they do actually, for example, traditionally have supported like banning someone from the community or even death sentences. So to say that every Indigenous person thinks that we should all be light on crime, that crime is the result of discrimination is not true. Certain people feel that in certain Indigenous traditions, they have a very different view. So I think this model fails to recognize the diversity within Indigenous cultures. Another critique, and one especially advanced by Indigenous women who experience disproportionate rates of violence and murder in Canada, it's a huge problem, is that these sentencing circles allow the very cause of the violence, the patriarchal structures that cause violence against women, they allow them to be reproduced in the context of a sentencing circle and allow for lighter sentencing. So what women and feminist Indigenous women have been advocating for is either not to use sentencing circles in the context of violence against women and gendered crimes, or to do them only when there's a huge amount of training and awareness made before on the seriousness of violence against women. The fact that something is normal in a community does not make it okay. That's consistent with Canada's international obligations under the Convention to eradicate all forms of discrimination against women. Tradition and culture is not a shield to discrimination and human rights obligations. So obligations with that regards. And finally, I think the biggest critique, and I'll end with this, is that it's not radical enough. A lot of people feel that it's tokenism, that it's just one thing that's done, but that obviously the real cause of over-incarceration in Indigenous communities is not the failure to apply restorative justice principles in the context of criminal law, but it's the history of residential schools and colonization. So until we get to these root causes, we won't see any changes in the incarceration rates at all. Some people feel that that it's a form of accommodation and that the whole system needs to change, and that the Indigenous people need the right to self-regulate and to self-govern, especially with regards to criminal law. So those are the critiques. Maybe I'll end with that and leave, I guess we have like 5 to 7 minutes for questions if anyone's had any thoughts. Yeah? Is there a mic? Does anyone have a microphone? No? Do you want to? Sí.
Me parece muy interesante este programa para profesores indígenas en Canadá, norma estos círculos de sentencia. Mi pregunta sería, ¿qué pasa con el resto de los canadienses que no son indígenas? ¿También tienen acceso a este programa?
Sí, I think I understood.
Ok, que me parece muy interesante este programa de justicia restaurativa dirigido a indígenas canadienses. Sin embargo, mi duda es si el resto de los ofensores no indígenas en Canadá también tienen acceso a este programa de justicia restaurativa, o es exclusivo para los indígenas.
Ajá.
Y si es así, ¿qué pasa con los ofensores canadienses que no son indígenas?
Ajá. Yeah. 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 So the question is, what about people who are non-Indigenous? Okay, so the section 718 of the Criminal Code only applies to Indigenous people, but there is a similar provision in the Criminal Code that encourages non-incarceration, and our Criminal Code does refer to values of restorative justice and like deterrence, participation, reintegration. So there are programs, and judges are encouraged to consider alternative modes of sentencing. But I guess for Indigenous people, it's that and that. It's plus. So they benefit from both kind of systems. Sentencing circles are only used for Indigenous peoples. It's a to my knowledge, it's a judicial initiative, and to my knowledge, it's only been used with regards to Indigenous people. Healing lodges, Indigenous people can request healing to take part in healing lodges, but Indigenous people will have the priority. And they also have to show an openness or to engage in these traditions, right? Because you have to, part of taking part of a healing lodge is to be accompanied by, for example, an elder. So the person has to show that they're an appropriate fit for these programs. So I hope that answers your question. Yeah. Okay. Gracias.
Muchas gracias.
Thank you. I'll try to make it in English. I hope I can make understood. As you know, in Mexico we have this problem, but in a major topic, we have thousands of original people. Mm-hmm. My question is that if the original people in Canada are bilingual, I mean, if they speak English and also the original language, if they all speak both languages, that could be possible that they understand the law, they can understand what's going on during their trials. But the problem could be if they don't understand English and they don't know what's happening with them during the trial. I don't know if they receive special assistance during this kind of process before the judges. I don't know what's the problem in that topic in Canada. I don't know if you got the question.
Yeah, I think I would say that most Indigenous people speak English or French, and a lot have lost their language, actually. There might be a small percentage who don't speak French or English, but I would say that that's really a minority, and interpreters would be provided. But a huge problem, I think, is actually Indigenous people not being able to speak their language because of politics of forced assimilation. And I think courts right now, and again, I'll go to my last point, of using restorative justice only in the criminal law system. I think that's when it's too late. It's good. We need to do it when it's too late as well, but I think we need to be more proactive and use restorative justice also in human rights and civil proceedings to make the courts more appealing to Indigenous people, because while Indigenous people are certainly overrepresented in the criminal process, they're very underrepresented in courts to affirm their rights. So we need to think of ways to make the courts more appealing and more culturally appropriate for Indigenous people, so they see the courts, the Canadian courts, as a mechanism to assert their rights in a way that's fair and culturally appropriate. I hope that answers your question. Maybe I'll just add there, we don't, currently our Supreme Court, we used to have actually more women than men. Our Chief Justice is a woman. We don't yet have an Indigenous person on the Supreme Court, but Indigenous people are, there are Indigenous people on the judiciary. So that's a good step to making the courts seem more receptive to those issues in Canada.
Hi, good afternoon. So my question is just for now, if you have some prevention programs for these people, or it's just when everything happens? There are prevention programs. I think
I mean, I think the best prevention would be equality. That's been my work. The focus of my work is to fight to obtain equal services and culturally appropriate services on reserves. But yeah, there are prevention services. For example, there are social workers on reserves, but to encourage kids not to turn towards criminality or suicide, for example. There is currently underfunding of certain services on reserves, like especially social services. So I think that's a problem, and it's probably a factor in the incarceration rates.
In your opinion, what is the best way to promote in the schools the tolerance in your country? Because in my opinion, tolerance is an important value.
Thank you. I think, well, first of all, the word tolerance, I think I prefer the word celebration. Tolerance suggests that it's, I tolerate my daughter when she's being grouchy, but I don't celebrate her. I think we need to celebrate diversity and feel that we're enriched by it. One thing that we're doing on a case that I'm working on with Indigenous people is that we're going into the schools with non-Indigenous schools also, and we're not just teaching them to be accepting of Indigenous people, but to demand equality and to be active participants in denouncing the discrimination that First Nations, Indigenous people experience in Canada. So we have a whole campaign of getting kids involved in writing the Prime Minister, in organizing protests to demand that First Nations children are being treated equally. Because I think tolerance is here, and then I think we need to demand action. We have to and recently in Canada, following the residential schools, we've had a Truth and Reconciliation Commission, and the Commission has urged non-Indigenous Canadians to read the recommendations and to demand action by government. Because coexistence is one thing, but I think we need to take it to another level to express solidarity and to take it to action, because I don't think tolerance will get us equality. I think we need to be more militant in demanding changes in our system.
Hello. I think average people thinks that Canada, the USA is on the top of the education, but I'm surprised because you are telling us several circumstances that you live in your country. Then I don't know, because most of us think that education is everything. Mm-hmm. And I am surprised because I think I used to think that Canadian people, it was on the top of the world, mm-hmm. with no problems. And why do you have that problems? Because we are on the first world and we are in the third world. I don't know why. Mm-hmm. I'd like to know your opinion, please.
Well, I think, to say it bluntly, Canada, we have a colonizing past. So there are certain, I think that's part of our culture, to see and to allow for discrimination to occur and to not be offended by it. I think it's part of Canadian culture. I think a lot of Canadians, well, I would hope that a lot of Canadians, the reason that they're not more upset by the situation is because they don't know. A lot of reserves are located, outside of urban areas. So I would hope that that's a cause for the lack of awareness. But I think that to say it bluntly, we are a colonizing nation, and there's certain underlining cultural elements that might remain. That, for example, the murder of Indigenous women, the reaction of there are over 1,000 cases of Indigenous women who've gone missing, who've gone and we don't know. We're not sure, and so the Canadian government is currently going to do an inquiry to investigate the cases, to examine the systemic discrimination that has allowed for these murders to happen, but also the failure of the state to respond in the police, because there's a huge difference in the public reaction when an Indigenous woman goes missing compared to when a blonde-haired, blue-eyed woman goes missing. The reaction is very different in the media and just in public culture. There's a huge difference. So I think there's still underlining racism in Canadian culture. I hope that's helpful.
Buenas tardes.
Amigo.
Mucho gusto. Me da un poco de curiosidad esto de las reservas. ¿Quién entra? ¿Cómo entra? ¿En qué condiciones? ¿Todos los delitos son considerados para tener este beneficio? ¿O el hecho de ser indígena tienes directamente ese derecho independientemente del delito?
Okay, yes. Okay, great question. So the sentencing circles, because they're so intensive, it takes a lot of resources to mobilize the community, to organize, and it takes a lot of time. So the sentencing circles are generally only used for more serious crimes, whereas less serious crimes, the judge will usually rely on Section 718 of the Criminal Code to consider Indigenous, the effect of discrimination and colonization on the accused. For healing lodges as well, healing lodges generally are more for the serious crimes, whereas the less serious crimes, usually there's a community integration plan, because really if the goal is reintegration into community, we should get them as soon as possible. That's the underlining rationale. Does that answer your question?
Thank you. Sí.
But like I said, there has been a movement by feminist Indigenous women saying that for gendered crimes like sexual assault or domestic violence against women, that those kinds of crimes are inappropriate for sentencing circles. So we'll see what happens with that. Yeah, thank you so much. Well, thank you so much. I'll be around if anyone has any question, but it's been an honor. Thank you.
En este momento invito a la licenciada Angélica Maya Salazar para que haga entrega del siguiente reconocimiento. A la doctora Anne Levesque, por la brillante disertación de la conferencia Justicia Restaurativa en Comunidades Indígenas de Canadá. Es así como finaliza esta primer conferencia.